Hi, welcome back to Jus Cogens, the International Law Podcast. This is episode 11. And today we are going to talk to Professor Dr. Simon Chesterman, who is the Dean of Faculty of Law at the National University of Singapore. He is a recognized authority on international law. He has worked extensively on the rules and institutions of global governance, state building, post-conflict challenges, and various other issues. He has also authored many seminal books, including The Law and Practice of the United Nations, Just War or Just Peace, and many other texts as well. Today, we are going to discuss Professor Chesterman's piece on Asia's ambivalence about international law, which was published in the Oxford Handbook on International Law in Asia and the Pacific, published in 2019. And it is juxtaposed with a similar piece in EGIL with a similar title. Thank you so much, Dr. Chesterman, for joining us today on the podcast. It's an absolute pleasure to have you.
Thanks so much for inviting me. Pleasure to be here.
Great. So just to get the conversation going, if you can just give us a brief background and overview of Asia's experience and contribution to international law, historically or any other way you want to address this.
Sure. So, basically, I decided to write this piece out of fascination because I grew up in Australia and then lived for a year in China in the early 1990s and have been based here now for about 13 years. And what fascinated me as an international lawyer was to be reasonably familiar with this area of the world, this incredibly dynamic, the most populated, economically growing part of the world that seemed to have the least stake in international law and institutions. So I was really curious to work out why that was the case and what it meant for current world order. And so obviously this has a lot to do with history, with the history of international law, the way in which it emerged, the extent to which it was dominated by European colonial powers and imposed on much of the rest of the world. And so that really led me to look at a couple of factors that I think have influenced Asia's engagement or lack thereof with international law and institutions. And maybe just to pick up two initially, one is that history, the history of the experience of having international law and institutions thrust upon Asian countries. They literally did not take part in the writing or in the writing of treaties and the development of custom because they were not recognized or given an inferior status. Of course, that wasn't unique to Asia. That was even more the case in Africa. And that led me to the second consideration, which is the power dynamics. That one of the reasons why Asia today, even as it's become this very dynamic part of the world, has not risen maybe to the stature and the influence that it might have, is because of internal divisions in Asia. And indeed, that's epitomized by the very word Asia, which is not an Asian word, it's a Greek word. And basically Asia as a continent exists kind of geographically, but not really politically. And very few people from Asia would identify as Asian in the way that Europeans, Africans, and Latin Americans might identify with their regions. So that's just, if you like, a kind of outline. We can go into more of the detail, but that's what started me on the journey that led to this article and this project.
Right.
So,
No, that's good.
Professor Chesterman, could you trace us briefly through the history of the three major powers in Asia, India, China, and Japan, and how their experiences have been towards international law or with international law?
Sure. Go ahead, please.
Historically and presently.
Yeah. So as I said, Asia doesn't really exist as a concept. Anyone who tells you there is an Asian approach to anything is either being creative or maybe they're being misleading. And so what I found as I started digging into this was that it was really helpful actually to look deeply at the experience of different Asian states. And indeed, the handbook that you so kindly held up a copy of just now was really a project to highlight the diverse and rich experience of Asian states and influence of Asian states on international law. But for my own research, it made sense to focus, and I focused in particular on three of the larger powers, China, Japan, and India. And so maybe to respond to your question, I'll go through a little bit of each of them, although each deserves book-length treatments in their own right. And so China, which I probably know best, China, they talk about, in China, they describe a century of humiliation. And this is one of the unusual things confronting the world order at the moment as China becomes a power to rival the United States, that in the history of the world, there's never been a power that rose twice. And so China in the Middle Ages, what Europe would call the Middle Ages, was a kind of world power at the center of a kind of, at least a regional order, where it was a dominant power, epitomized by the name that China gives itself, the Middle Kingdom, Zhongguo. But with the arrival of the Europeans, the Opium Wars, the unequal treaties as they came to be called, the Chinese view of international law, I think, really coalesced around a view that international law was an instrument to be used rather than a set of rules to be followed. And that was reinforced by two things. One was this experience of having treaties thrust upon it, which arguably these days would have been void for coercion under the Vienna Convention on the Law of Treaties, but treaties that were thrust upon it by European powers that it later denounced as unequal treaties and subsequently negotiated its way out of. That experience combined with the experience of China through the 20th century, where China was not recognized for decades, even in the era of the United Nations, when Taiwan, what the People's Republic of China regards as a renegade province, was representing China in the United Nations. China, I think, really viewed international law essentially as a political instrument. The second aspect of the Chinese experience that reinforces this view, I think, is the domestic Chinese view of law, where the Chinese Communist Party exists at the apex of government. So there is a court system, there is a functioning, at least ruled by law, some would argue rule of law system, but the Supreme People's Court sits at the apex of that legal system, but still under the Chinese Communist Party. And so this really reinforced for the Chinese, certainly, a view of international law as, and indeed law generally, as an instrument that can be used, a politicized instrument. And so when China, for example, is exercising what it regards as its national interest in the South China Sea and is subjected to an arbitral settlement that it didn't consent to, they regard this essentially as a political interference. And that, I think, partly explains its resistance to the arbitration, more recently followed up by the US support for an interpretation of the obligations with regard to the South China Sea that do not allow China to claim any exclusive economic zones and so on. So that, if you like, is a very, very brief, inadequate history of China, of being excluded really from the international system. Japan was very different. Japan was recognized as the most advanced of the Asian powers, partly because it defeated Russia in a war, partly because of its technological sophistication. And so Japan, after the Meiji Restoration, really did try to engage with the European powers and to play more of a role in the construction of international regimes. But the limitations of those regimes were clearly on display when in the negotiations to create the League of Nations Covenant, Japan pushed for a racial equality clause and was rebuffed. And this really did, I think, strike many Japanese as indicating the limits of their acceptability by the Western powers, that they were not being treated as equals. And so that was part of the Japanese experience. And then, of course, we have the aftermath of the Second World War, where Japan, I think most Japanese these days would acknowledge the wrongs that Japan perpetrated through that war and the surrounding episodes. But the aftermath of that war saw what many in Japan would regard as a selective prosecution. And so the fact that the emperor was left in place, that this was a political deal in order that was negotiated in part by the Americans to try and maintain order in Japan, I think this encouraged a view of international law as a selective regime that has made it hard for some Japanese, at least, to embrace fully the international order, although certainly Japan has done more of that than China. And then a third country, of course, is India, and which, of course, incorporates, at least in the early period, Pakistan, but now a separate country along with Bangladesh. And the Indian experience was very much very different from the Chinese and the British and the Japanese experience, which was really international law as the defender of colonialism. And international law was used to legitimate the colonial enterprise, to perpetuate it in many ways. And so I think this led to a great suspicion that, that international law really was not so much about justice as about power. And maybe that's true, but I think that does explain some of the wariness, at least in the early years, of embracing these institutions, which when the period of decolonization took place, there was, I think, a brief period of exuberance. So with the independence of many colonial countries, India, among others, pushed for a new international economic order. There was an effort to make international law more just, to use the numerical majority in the General Assembly to hold the great powers to account, the smaller number of great powers. But it was not particularly successful. And so the new international economic order of the 1980s didn't really go anywhere. And what we've seen more recently is India really pushing for status. So investing a huge, I would say, an irrational amount of effort in getting a seat on the UN Security Council, for example, which is an understandable aspiration, but also an unattainable one, given the current political dynamics and the steps that would be necessary in order to get onto the Security Council, which would require the P5 agreeing to it, which at least in the foreseeable future seems unlikely. And so if you like, in a microcosm, these three states epitomize the problematic view of international law as, in the case of China, an instrument to be used. In the Japanese case, as a selective tool applied when politically convenient. And in the case of India, the legitimation of power rather than a restraint on power. Now, despite all of that, Asian states actually comply with most international law most of the time. But I think all of these reasons, along with what I highlighted earlier, which is the power dynamic, are some of the reasons why today we see Asian states being somewhat suspicious of international law institutions. And that's borne out in the fact that most Asian states, or rather Asian states, are the least likely to be party to almost any international regime. And this is not just human rights regimes, although that is the case, but also things like membership of the World Trade Organization, being a state party of the ICSID Convention, the International Center for the Settlement of International Disputes, or to be represented on the institutions of global governance in proportion to their number and influence. And so that really was the puzzle that I was struggling to grapple with all the time, which is what happens when an international order has the most powerful region and some of the most powerful countries having the least stake and the least say in that order. But that's where we are today with Asia.
So, Professor Chesterman, thank you so much for providing such an extensive overview of the historical sort of inclinations of these three countries. And probably taking it a little further from there, just looking at, for instance, the recent approach that China has taken, even within the last couple of months or 1 year, in terms of asserting itself on the international plane, sits very well with your analysis of how China tends to use international law as an instrument to accrue more authority, more power, but sometimes at the expense of the law itself. Of course, it's a statement that may be a bit controversial, but do you see then, because one of your analyses is that a continuation of the status quo is potentially to be expected in the way that sort of Asian states interact with international law. Do you see that continuing, or do you see then now a sort of paradigmatic shift with the way that international law will be treated in the future, given that there is a significant growth of how do you see the United States receding and China sort of coming to the forefront of managing these positions of authority?
Right, so I certainly do see the US receding and China rising, and I should emphasize that the US receding predates the current occupant of the White House, although I think Donald Trump has accelerated all of that. Mm-hmm. But on the question of China, I mean, this is in some ways the question of the century, is whether China is a revolutionary or evolutionary power. And until recently, I would have said definitely evolutionary, and the recently I'll come back to. So through the early 21st century, China really took the position that although it was a rising power, it didn't want to be treated as a great power. It didn't assert that status. Indeed, so I was living in the US in the early 2000s in New York, and one of the fascinating things was to watch the way China behaved on the Security Council. So through the 1990s, China would typically abstain, not say anything.
Mhm.
But then through the 2000s, they started to get more involved to the point where now they actually have more peacekeepers and civilian police on the ground than the other 4 permanent members of the Security Council combined. So China has started to become more engaged as a good citizen, if you like, in the international order. But through the early 2000s, they really did stick to Deng Xiaoping's urging of Tao Guang Yang Hui, which means to basically nourish obscurity, to cultivate obscurity, to keep your light under a bushel, if you like. And going back to just to that period of 2000s, in early 2001, some of your listeners might be too young to remember this, it's almost 20 years ago, but the US at the time saw China as a potential rising threat. And there was the beginning of the language of containment, that it might be necessary to contain China, to balance China. The US went through a kind of strategic review after Bill Clinton stepped down as president and George W. Bush stepped up. China went from being termed a strategic partner to a strategic competitor. And in April, I think 2001, was the EP-3 spy plane incident, where an American spy plane collided with a Chinese jet, and the American plane had to land in China. And so there was a real period of tension. And then September 11, 2001 happened. And suddenly China was off the radar. And the United States started focusing on failing states, obviously engaged in wars in Afghanistan and Iraq, and China literally was not on the agenda for many years, and that sort of suited the Chinese perfectly, because what they wanted to do was develop their economy. They had the 2008 Beijing Olympics, and really rose as a good power, what many people regard as a good power. So all through that period, they made no indication that they had an aspiration to global dominance. They didn't want to challenge the US security presence in most of the world. But they had a certain view of China was, and China meant Greater China, which includes Tibet, Taiwan, Hong Kong, Macau, and so on. So as long as you didn't threaten that, maybe including the South China Sea, as long as you didn't include that, then China wasn't bristling against the United States. More recently, however, China has become significantly more assertive. And so, as you mentioned, just in the last few months, to pick a few examples, we've got reassertion of its rights in the South China Sea. We've got the national security law passed in Hong Kong. We've got the border incident with India in the highlands up there, which led to about 20 Indian soldiers dying. So this is significantly pushing at the limits of order. But does it mean, to go back to your question, which was a long time ago, I apologize, does this mean China is rejecting international law? No, because China is actually quite careful in its public statements not to reject international law. And just to give you one example, the South China Sea, although China rejects the finding of the arbitral tribunal, although it rejects both the form and the substance of the dispute settlement procedure, it has not renounced the UN Convention on the Law of the Sea, which overall is beneficial to the Chinese, to China. It has not walked away from institutions the way, for example, we're now seeing the US walking away from the World Health Organization, or at least trying to. And China has usually been quite careful to argue substance and not foundation. Mm-hmm. So it will argue that it has rights in the South China Sea, but it won't necessarily define those rights. It claims historic title without saying that this is a variation of the obligations under the Law of the Sea Convention. And so what I think we're likely to see, in fact, is broadly comparable to what has happened with Taiwan over the past several decades, which is that China is quite happy to tolerate ambiguity for a long period of time. It will not, if it can avoid it, it will not start a war over Taiwan, but provided Taiwan also does not declare independence, we will continue to see, as we have for several decades, this odd status that there is essentially a country, many people would call it, but other countries don't have embassies there, they have trade representative offices. And so everyone maintains this charade that Taiwan is in theory part of one China, while in practice dealing with it separately. And that I think really does explain the Chinese approach, which is ultimately pragmatic. that China does not want to replace the US as the guarantor of world order, but nor these days does it want to be subject to US diktat. And if we can continue to navigate the fine line where that doesn't lead to a hot conflict and wars are limited to trade wars at worst, then perhaps it's sustainable.
Thank you for that.
Right. So how do you see the Asian participation and representation in international law recently and even historically as compared to the experience of Latin American and African states? And how do you see it going forward?
And really quickly, just one question. In addition to Omar's, it's you mentioned already the discrepancy between, for instance, Latin America, Africa, and Asia, and in that Asia is not one single unit, and the others are. But even given that, I think I still think for myself and also for the viewers, there is this confusion about that discrepancy as to how these other continents have been able to sort of, for instance, instrumentalize international law in the way that Asia has not been able to.
Right. So maybe to go backwards, the regional question. I think regional dynamics can be both. There are both carrots and sticks. And the carrot is if you can link economies, increase efficiencies, share or allocate comparative advantages properly, then sort of Europe, I think, is an example of pull factors along with trying to avoid another conflict. To some extent, we've seen that in Africa and Latin America, but push factors have also driven both. So in the case of Africa, the resistance to donor pressure and the sort of unity in numbers, I think, can be seen in the Organization of African Unity and then the African Union. And a more recent example of that kind of turning inwards can be seen in the resistance to the International Criminal Court and the perceived overemphasis on African leaders being held up for criticism and prosecution. Latin America, the fact that you've got this enormous economy of the United States and the problematic relationship many Latin American states had with the US, I think also drove a lot of the dynamic creating the organization of, so there's Latin America and then there's the Organization of American States, which of course the US is party to. But that identification, I think, is both inward and outward looking. Inward looking if there is a real regional identification, and outward looking that most communities are defined not just by who we are, but who we are not. In the case of Asia, Asia is so diverse and so big and has such big powers, including but not limited to China, Japan, India. I think many Asian states would be quite wary of identifying with and delegating any kind of power to Asian institutions as such. I mean, I can imagine Pakistan would be very wary of being in an institution where India would have a dominant role. China and Japan would have wariness about institutions where they play competing roles. And indeed, we've seen that with China setting up an alternative to the Asian Development Bank in the form of the Asian Infrastructure Investment Bank. Now, bring that forward to today. What kind of role can and should Asian states play? Can they play that key role? I mean, I think Asian states are playing more of a role, and certainly individual Asians have always played a key role. We've had Secretaries General of the UN like U Thant and Ban Ki-moon. We've had, from Singapore, where I'm based, Tommy Koh, one of the architects of the UN Convention on the Law of the Sea. We've had fine judges on the International Court of Justice and so on. In terms of the expanding role, I mentioned China's involvement in peacekeeping, but China's involvement is vastly overshadowed by the South Asian contributions to peacekeeping. I mean, if India, Pakistan, and Bangladesh withdrew from peacekeeping, that would be the end of peacekeeping. There are tens of thousands of troops around the world, most in Africa, who are contributed by South Asian states who have contributed enormously to peacekeeping. Leadership of international organizations. So China recently failed to get its candidate appointed as Director General of the World Intellectual Property Organization, WIPO, which is now going to be headed by a Singaporean and one of my alumni from NUS, Darren Tang. But one of the reasons why China failed in its bid was that 4 of the specialized agencies of the UN are already headed by Chinese. So China is not, I think, engaging in a takeover, but China is trying to play a larger role. And I think we will progressively see other Asian states try to play a slightly larger role. And one other example, maybe closer to home for me at least, is the Association of Southeast Asian Nations, which is a 10-member regional organization. And this, in many ways, epitomizes some of the challenges of regional organizations in Asia. Because this 10-member organization, really, I sometimes explain to people, all you ultimately need to know about ASEAN to understand its role is its budget. And the total budget of ASEAN is about, I think at the moment, 22 million US dollars in its entirety. And that amount is paid for equally in 10% shares by each of the 10 members, which means Singapore and Indonesia and Laos, Cambodia all pay just over 2 million US dollars per year into this organization, which is less than many of them put towards the UN, and which is even the smallest put towards the UN, and which would be, for example, a rounding error in the translation budget of the European Union. So in Asia, we don't really have that regional organization, but I think there is this developing willingness and aspiration to playing a greater role in the organizations that do exist, and for states not to just be rule takers, but if not being rule makers, at least playing more of a role in the creation and interpretation of international law.
Just ask a small follow-up to that. Why do you think that is, that smaller regional organizations like ASEAN and SAARC have unable to meaningfully contribute substantively to the international legal order as compared to other smaller continents? Because they are smaller setups within a larger continent. So apart from budgetary issues and political rivalries, what other factors do you think are important in understanding their failures?
Well, so the budgetary issue is a product of the political rivalry and is linked with the restrictions on impact. So the political rivalry translates to an unwillingness to delegate sovereignty in the way that it took decades for the Europeans to do this, but they have. It took a long time for the Africans to do this, but they have. And probably in terms of, in addition to political clout and budget, just having a court system that produces law would be a major step. And so having the African Court, for the African Charter of People's Rights, having the European multiple courts, the Latin American courts, they play more of a role in the law, but it also goes in the development of law, but it also goes to sort of what people think these organizations are for. And I think it is striking that any regional organization or an international organization, intergovernmental organization, can be thought of in different ways. And indeed, you mentioned the book, which I didn't write, The Law and Practice of the UN. I co-wrote it with David Malone and Tom Frank, and the new edition with Ian Johnson. But what we do when we teach a course built around that book is start with a question, just looking at the UN. What is the UN? Is it a thing or is it a place? And that's a good question to ask of any regional organization. Is it an institution with aspirations, power, implementable tasks, or is it a forum? And for the most part, Asian institutions tend to be forums. So that's true of ASEAN. The ultimate dispute resolution mechanism is it goes up to the foreign ministers or to the heads of government. It's true of SAARC. It's true of the Shanghai Cooperation Organization, which is another significant but very thin regional organization. So the reason why Asian states have that limited influence on the law is that they're not willing to, at least the regional organizations have a limited influence, is that the member states have designed those regional organizations to be weak. Now, that's not a bad thing. That's just reflecting the reality of politics, what the member states would agree to at the time. But it is necessarily going to limit the influence on the international stage.
Professor Chesterman, assuming that there won't be a significant shift in terms of the international legal order in favor of Asia or in terms of Asian participation, how do you see this specifically in terms of the changes in the international financial order? And by that, I mean, for example, the trade agreements which are being conducted under the ASEAN framework as sort of alternate to the WTO framework, and then China's leading role in terms of the Belt Road Initiative and its participation in the AIB, and the participation of some other states, even with the opposition of the US, and how does it serve as an alternate to WTO, to the IMF, and to the World Bank?
So this is one of the extraordinary things we've seen in the past few years, where America, the bastion of free trade, architect of the Bretton Woods institutions, has turned protectionist and is imposing tariffs, decrying free trade. And the leader of the Chinese Communist Party hops off to Davos to trumpet the virtues of globalization. It's an upside down world in some ways. In terms of what's happening now, I think most Asian states have recognized the values of trade. And in some ways, it's easier not to have the United States as a party to those agreements. The question then is, in what circumstances can you adapt to what extent can you adapt existing international regimes, or to what extent do you need to create your own? And so China, through both the Asian Infrastructure Investment Bank, the Belt Road Initiative, has really tried to position itself at the heart of an alternative to at least the World Bank, or the very least the Asian Development Bank. But I think that China and most Asian states also see the benefits of a truly global trading regime. Now, the unknown here is to what extent the US is just a convenient whipping boy. So the World Trade Organization's dispute settlement mechanism appellate body ceased to function, ceased to be able to take on new cases back in December. It issued its last decision in June because of US opposition to appointing new judges or new panel members. And that's been widely criticized, and it predates Trump also. That started with Obama. So it's been widely criticized, but that kind of criticism sometimes is opportunistic. So when the US can be held up as a villain, that enables states to have a certain degree of flexibility in their own policies. Now, you mentioned ASEAN. ASEAN, I think, is in many ways an extreme case of the pragmatism of Asian states. So certainly from the Singapore perspective, one of the reasons why Singapore is a strong advocate of ASEAN and ASEAN's economic agenda of lowering tariffs, loosening trade restrictions, and operating eventually as a single economy, is that Singapore is tiny. So Singapore has a population of about 5-point-something million people, a couple of $100 billion economy. But if Singapore doesn't want to be the political center, but if Singapore could be the economic or financial center of ASEAN, then that moves to being not a 5+ million population, but 600 million population, not a couple of $100 billion economy, but a several $1 trillion economy. And so to the extent that those economies can be integrated, that trade can flow across borders, that should be beneficial to everyone. Now, there are other reasons why it's a little bit easier for places like Singapore. Singapore has virtually no agriculture, so free trade agreements are a lot easier. But I think that pragmatism is what is driving the greater encouragement of trade, that you have expanding economies, assuming we get through this awful hiccup of the COVID-19 situation. And to take advantage of that, they need open trade routes. And when, in some ways, the US, it's almost easier to have the US outside of that negotiation, because you can have a much more even-handed negotiation, or at least that's what the Chinese might say, although many states might prefer it if China was also absent, because China can also be a difficult negotiating partner.
And just as a follow-up question, so how do you see China's role in terms of this economic development? So, for example, the leverage it will get through these initiatives and through extending loans to all these states as part of the Belt Road Initiative, and then an additional role which we're seeing, just so China's role in Iran, and especially sort of in defiance of the US domestic law sanctions. So do we see a bloc, or at least an Asian bloc, even if a small one, being formed, which can perhaps speak with one voice, which is something that we don't see at present?
So to start with China, so China was initially regarded as problematic by Western donors because it would issue loans without pesky conditionalities like human rights, labor standards, and so on. And so initially the Chinese argument was deal with us, not with the West, because we won't force you to change your practices. And I think there was a receptive audience to that kind of argument because there was a degree of irritation at the way in which Western donors and Western country investors had conducted themselves. That was until some of the honeymoon period of the Belt Road Initiative wore off. We saw some of the debt diplomacy, the debt traps that countries found themselves in when collateral started being collected by the Chinese. And so there might not have been human rights conditionality, but there were strict terms to be enforced. And if if payments were defaulted on, then the Chinese would either take over assets or, as we saw in some African states, send in their own personnel to run entire operations in a manner that ultimately was not regarded as quite what some of those African states had signed on to. So we've seen that one aspect to it. A second aspect is the reason for the Asian Infrastructure Investment Bank was set up as an alternative to the Asian Development Bank of the World Bank, was in part to avoid some of the restrictions of those institutions, but also essentially to give China a veto over certain decisions. And so China was quite clever about this, setting up the Asian Infrastructure Investment Bank such that it had just over, I think, 30% of the initial capital, which is not a majority, but it was sufficient to block any supermajority which is necessary for important decisions like appointing the president of the bank. So all of this is about China, but your question was partly about Asia. And no, I don't really see a path to a quote-unquote Asian set of views on almost anything. Because as much as many Asian states might be irritated by Western criticism that periodically comes up, or troubled by what's been happening in the United States over the last several years, I don't really see a forum for even just China, India, Japan, or bring in Pakistan, other large countries. I can't see them taking a formal position on anything as Asia. And so this kind of brings me back to my conclusion in that essay you've kindly mentioned at the start, which is that if there is a commonality among Asian states in terms of their attitudes towards international law institution, it's actually quite a traditional one, in many ways a conservative Westphalian one. That's certainly true of China, perhaps not of India. India's a little bit different. But for many Asian states, the primary value of the international order is sovereignty. And that, again, going back through the history, that's partly because that independence, that sovereignty was so hard fought. The pain that was endured in order to achieve independence is such that giving that up easily, it is not a perspective that many Asian states would embrace. And so when told to sign onto human rights treaties or accept labor standards that they didn't necessarily choose themselves, there is resistance. And that's true with regard to Western powers, but it's also true with regard to other Asian powers. And so the jealousy with which sovereignty is guarded, I think, is, again, one of the reasons why getting a common Asian position on anything is going to be difficult. And we see that at the United Nations, for example. So in the UN, there are different regional groupings. There's the Africans, Latin American, Caribbeans. There's still Europe. There's still a kind of Eastern Europe, although more than half of them are actually EU members. And the Western Europe and Others group, which includes Australia, New Zealand, Israel, Canada, the United States. The Asian group is the only one that basically doesn't talk about any common position on anything. All they talk about are candidacies, so how to allocate votes. And so there's virtually no common Asian position on anything. I don't see that as a bad thing. I don't think there necessarily should be an Asian position. Asia's too big and diverse. But I do think it limits the ability for there to be a kind of alternative Asian approach to global order or international law.
Professor Chesterman, as we bring this wonderful discussion to an end, if you can just have your final thoughts on the future of Asia's ambivalence towards international law, given that China has increased its role in international legal order, and India is also pushing for a seat in global leadership. How does that shape the future of Asia's participation in international law?
Right. So, I mean, for all that I've been saying, I'm actually quite optimistic because the fact that there's no one Asian position, even as all of Asia rises, means that the most likely scenario that I can see is that as Asia and Asian states and citizens of those Asian states play more of a role, it won't lead to a kind of alternative bloc. This is not the Soviet Union rising against the United States. Now, there might well be great power tension between China and the United States, but on Asia as a whole, the extent to which Asia rises, it won't lead to a kind of bipolarity. It'll lead to a plurality, because the diversity of Asia means you get lots of different Asian voices.
Right.
Now, the downside might be that this will slow down some of the agenda, some of the human rights agenda in particular that's been pushed over recent years, things like responsibility to protect, that might all slow down. The fact that Asian states tend not to sign up to compulsory jurisdiction of the ICJ, that might slow down international dispute settlement. But that plurality, I think, is a healthy thing for the world order for two reasons. The first is that if you have the institutions of global order not representing a majority of the population, so approximately 60% of the world lives in Asia, that's a problem. But the other reason it's a good thing more positively is you have this incredible, not just diversity, but enthusiasm, willingness to get involved that we now see in many Asian states. So Asia, for a long time, was the region of the world that didn't have a Society of International Law, for example. We've now got one. We've got an Asian Journal of International Law. We've got young people across the region getting more involved, more interested. And so my hope is that as the kind of global paradigm shifts slightly, slowly, what it will do is not lead to a kind of sudden redirection or a sudden bifurcation, but rather an opening up where more of those people can have more of a say more of the time.
All right, perfect. On that optimistic note, we'll conclude the podcast. Thank you so much, Professor Chesterman, for this insightful conversation on the matter. And we'll see you in the next episode.
Yep,
Thanks so much.
It was fantastic to have you.